So good afternoon, good morning, good night, good early hours if you are in Australia, New Zealand, or Japan. And it's a privilege to be hosting this SIEL conversation. It's the one that just precedes the SIEL Global Conference, so it works as a warm-up for the conference. This conversation, I must say, my name is Geraldo Vidigal, although my tag says Society of International Economic Law. I'm a member of the executive committee, and I'm one of the people responsible for these SIEL conversations. I must say this particular conversation was the brainchild of Amy Porges, who's here, and who is founder and partner at Porges Law, PLLC, Porges Trade Law. She has decades of experience in international trade law and has been the senior counsel for dispute settlement and head of enforcement at the Office of the U.S. Trade Representative in Washington, D.C., managing the USTR's WTO and NAFTA litigation docket and strategy and procedural issues in the WTO and NAFTA disputes, participating in over 100 cases during the WTO's first 5 years. Besides her and myself are Fernando Piérola, who is a senior counsel at the CWL, so the Advisory Center for WTO Law. He's an international lawyer in arbitration. He's of Peruvian and Swiss nationality. He's been an active arbitrator in regional trade agreement litigation, both in trade disputes and investment disputes, and has more than 2 decades of experience in international law, has acted as counsel in some of the most high-profile WTO disputes, and has been appointed as arbitrator in several investor state and free trade agreement disputes. So the fourth participant, unfortunately, cannot be with us today. She had a last-minute family health emergency. And that's Annelies Winborne, who's Deputy Assistant U.S. Trade Representative. And it's a shame, but I believe we have sufficient expertise in this panel, including in U.S. disputes, to allow us to have a meaningful debate. Then Thomas Liefländer is Deputy Head of Unit at the Directorate General for Trade of the European Commission. He's currently at the Legal Affairs dispute settlement for trade and sustainable development and investment unit, has a decade of experience in addressing European and international law matters at the European Commission. Finally, Orlando Pérez is an internationally recognized legal expert with more than 20 years of experience in international trade and investment issues and disputes, currently partnering with TMI Abogados, or TMI Abogados, in Mexico. He has counseled for high travel trade disputes and investment arbitrations, and was counsel and lead negotiator for the intellectual property chapter of USMCA, and was part of the team working on the modernization of the FTA between Mexico and the European Union. To finalize by introducing myself, I'm Geraldo Vidigal. I'm assistant professor at the Faculty of Law of the University of Amsterdam, and I'm coordinate here the LLM in International Trade and Investment Law. I'm also managing editor of Law Journal, Legal Issues of Economic Integration. And prior to joining the university, I worked as a dispute settlement lawyer at the World Trade Organization. So with the introductions done, thanks everyone for being here. Thank the Society of International Economic Law, especially the 2 vice presidents, Isabel van Damme and Marcus Wagner, who has been really instrumental in allowing us to be here and are working hard to organize the conference next week. I tell you all to follow us before I forget. Follow us on Twitter, so at SIELnet, and whenever if Twitter disappears, it's probably going to be at SIELnet at something else as well. So thank you very much for all of this. So maybe we start by discussing the state of international dispute settlement, and now under regional trade agreements and how they're replacing the WTO or complementing the WTO as sites where states and international organizations settle their disputes. And maybe I start by giving the floor to Amy so that she can introduce her idea for the panel and how she sees things are going.
Well, as is quite obvious, the WTO has not been doing so well as let's say there is a decline in the revealed preference for bringing disputes to the WTO. In the peak year of 1998, I think there were like 50 disputes filed That was 1997, and even in 2018, there were 38. But over the last 3 years, 2020 to 2022, there have been 7 disputes a year, some of which have gone nowhere, but some of which have been simply settled, and some of which have resulted in panel reports that have been appealed into the void. So it's an issue. So the question becomes, does regional trade agreement dispute settlement become another way to settle problems? How are governments actually settling their issues? Because the thing about a trade dispute is you have to settle it through some kind of dispute settlement mechanism, or else you have to fall back on diplomatic means. Dispute settlement mechanisms are the way in which a smaller party or a party that has a great, let's say, legal case and wants to enforce the rules of the free trade agreement can get traction, even though the other party doesn't want to even talk about the dispute, has larger economic power, and let's say also power in this sense is relative. You know, 2 small countries may have a big dispute, and if one is larger, the smaller one may have a very tough time enforcing its rights. So there's regional trade agreement dispute settlement. What are the positives and the negatives of using it? What are the obstacles to using it? Is it being used? Has it not been used? I don't think there actually is a fair amount of use in the past of regional trade agreement dispute settlement in Mercosur, in SIECA, in Central America, under African agreements, of course, under the Canada-US FTA, under NAFTA, and now under USMCA. So there is, in fact, use of this stuff, and how are governments using this as a tool in the toolbox? That's the question. Because in the end, because why are we doing these agreements to begin with? Why have we done these agreements to begin with? Because stakeholders wanted them. They wanted to be able to make something here and ship it there and have certainty that it would work over the years. And that's what trade rules do. And for that to happen, trade rules need to be enforceable.
Thanks, Amy. So I see Fernando, who has a lot of experience speaking on behalf of developing countries, will have something to say about that.
Well, thank you very much, Geraldo. I think that's Amy has raised a very interesting question. I guess certainly, I mean, there is always this open question as to whether RTA dispute resolution could be a substitute for, multilateral dispute resolution. I think we cannot forget the fact that in order to consider this regional, the regional forum as an alternative, substantively, we have to talk about, an overlap in terms of substantive obligations, in the sense that there must be obligations that could be enforced under either, WTO or the regional forum. And I think in terms of the evolution of RTA disputes, we have to see whether the increasing number of RTA disputes arise, from cases in which there is this option available, or otherwise we're talking about disputes of a specific regional character, for which there is no option. I mean, for which there is no choice. You have to use the regional mechanism anyways. I guess the decline in terms of the activity of the WTO dispute settlement system in the past years, I think Amy referred to the most appropriate figures here. In 2018, we have a peak of 38 disputes there. Then afterwards, it declined to 20. Then it went to 5 during the year of COVID. Maybe explained by different factors. I think I would just say generally, I think there could be, some problems attributed to, the institutional crisis that we're going through in the dispute settlement process with the absence of a functioning appellate body. COVID, I think, also, had a significant impact, and also the international tension we have in the world currently, for which, the parties involved may have thought of means other than dispute resolution, like diplomatic means. Thank you.
Thank you, Fernando. So maybe now I would like to hear from Orlando, because Orlando has been negotiating, and of course, part of a country that is not particularly small. That's Mexico. It's quite a powerhouse in certain industries. but also has been negotiating and litigating agreements into agreements with far larger partners. And so, how do you see this dynamic between who wants to make RTAs more enforceable normally? Is it the larger economies or is it the smaller economies?
I think both sides can contribute that to have an agreement, to have international obligations that could be enforced. So everybody that sit down and negotiate a trade deal usually have in their mind that those rules needs to regulate the relationship between the two, three or several states. But at the end, everybody knows that there could be some gray areas in which they can pursue their political decisions or public policies, that they can continue working with this type of perhaps fear that someone can trigger a dispute against you, or you can trigger a dispute against your trading partner. No, so all trade relationships has this issue of trade irritants that you want to solve, and a trade deal, it's supposed to provide you the rules of the game, and that rules of the game needs to be enforced. So all sides want to have the enforcement of the rule. The issue is when you have a very highly political sensitivities in one trade irritant, it perhaps when becomes difficult to enforce a specific provision.
Thanks, Orlando. So that's a great segue into, Amy has a point. Just one last thing. I'm remembering back in the 1990s when Mickey Cantor was very proud of going around and negotiating a lot of trade agreements. And then, so he went to Congress, and then the response he got was, yes, and are you enforcing them?
Yes.
Just say.
Very good point. But that's an interesting segue into my question to Thomas, which is about the EU's approach to dispute settlement, and especially the EU's recent decision to make align the TSD, the Trade and Sustainable Development Commitments, the enforcement of these commitments with the enforcement of trade rules. And of course, being from Brazil, I'm going to refrain from discussing this particular issue in the context of the EU-Mercosur negotiations. But of course, those who are listening to us will be very interested in hearing how this is being discussed and what is driving this evolution of this policy.
Yes, thank you so much. There's a number of interesting questions already raised by the other speakers, including on the issue on WTO versus FTA dispute settlement, which we might come back to later. But on your question, so the evolution of our dispute settlement policy for FTAs on TSD and other issues, I think you can, broadly speaking, put the driving factors into two baskets. One is, let's say, the substantive policy evolution itself, and that I think is where the TSD review innovations, let's say, come in. And then you have more practical matters, which are what I would call learning from experience. So on the first one, of course, dispute settlement is, so to speak, at the end of the process. You have your obligations and you want to make them count. So other speakers have already said you want to be able to enforce them. And TSD, at least in the EU's sphere, has for a long time taken a bit of a special role. It's had its own special dispute resolution mechanism. In part inspired and building on the general dispute resolution mechanism of the FTAs, but different. And over time, with the overall focus on enforcement of trade agreements, including the TSD chapters, but also the overall greater wish of our stakeholders, the various institutions at play here, to become more focused on TSD in particular. In the TSD review, the decision was taken to, as it was put, align the dispute resolution mechanisms more. So what you see now in the more recent agreements, and New Zealand is, of course, the first one, is that we've actually, in that agreement at least, abandoned the approach of a special TSD dispute resolution mechanism and brought it into the realm of the general dispute resolution chapter with a number of small specialties. And of course, on the main issue of sanctions, you see that there's let's say, a tailor-made approach for some violations. I think what it clearly highlights is that these obligations are seen like obligations like any others in the trade agreements, and the interest in making them enforceable and being able to go ultimately to a fully functioning, fully developed dispute settlement process that is not in some way inferior or special compared to the way other trade rules are enforced, with the small exceptions of sanctions for some types of breaches, clearly puts, I think, the emphasis on the interest in making those rules fully count. The second basket of driving forces, and then I'll be quiet, I think is more the practical side, in that we learn from our own experiences in these disputes. So after every dispute, we've had a number now, under our FTAs, we of course evaluate our rules from a very practical point of view. Fit for purpose, are they running properly? And we look, of course, at the disputes that are running under other agreements as well, and see what innovations are there. So if you look at the evolution of our dispute settlement chapters, you see that they're, I think, responding both to substantive policy evolutions, but also to more practical, how do we actually make these work in practice, building on the experience that we and others have over time. Thank you.
Let me then give the floor back to Orlando to discuss this, especially, of course, because in the US-Mexico-Canada agreement, or TMEC, you have more than regular, more than an equality between trade provisions and labor provisions in particular. And you have this whole rapid response mechanism, which has been the most active means of using this agreement at all, and without dispute. So that has been operating essentially through the United States calling into question the way specific plans work and being able to trigger this mechanism. But on the other hand, of course, Mexico has a government that, at least to the outside, seems like to be very focused on increasing labor rights. So I wonder how that's being perceived, and how that system is looked at within Mexico. Of course, Mexico once started its own sort of minor dispute regarding also the workers in the United States, but I would like to hear your opinion on that. You have to unmute yourself.
Sorry. Thank you so much, and this is pretty interesting of what Thomas has mentioned. And in the case of Mexico, we need to remember that the discussion about labor and environment provisions in the trade agreement, and particularly on what is incorporated in the USMCA, it parts, I guess, of the development of the discussion on trade and environment and trade and labor from the time of the WTO, and then with the negotiations of the TPP. In which Mexico took the decision, along with the other partners, to incorporate those chapters in an FTA and accept, for example, that those provisions will be enforceable by the dispute settlement mechanism. But I guess that Mexico, along other countries, has in their mind that perhaps we need to have some previous steps to deal with these issues, in particular, for example, environmental consultations or other previous stages like labor consultations or specific and technical meetings or political guidance with respect to those issues. At the end, in the USMCA, when it was negotiated, probably you remember that the labor chapter and the environmental chapter was subject to the dispute settlement. But the Democrats, when they have this discussion in the Congress of the agreement that was signed in November 2018, basically pushed that it was not enough, particularly on the labor issue. So they open the text, they create this rapid response mechanism. And in the case of Mexico, there was a change of the administration, and the new administration was very vocal in favor of the labor rights. So they thought that it was a useful idea to have this mechanism. The mechanism has, as you mentioned, has been used 11 times, but I think that the main element in the 11 cases is that 10 has been focused in the automotive sector. The last one is in the mining sector, and has in some way the specific company that triggers or that is subject to the investigation and the collaboration of the Ministry of Labor of Mexico, the labor authorities of the US, USTR, and the trade officials in Mexico has been able to solve this issue without moving to a panel stage. So it has been pretty quick. I think it has helped perhaps that some specific enterprise in Mexico can fix some problems that perhaps it was not being solved without this mechanism. And I think that is still a mechanism that is, I guess, in continued practice, and perhaps we don't know how what will be the end of the story if one particular case moves to a panel stage. No, we have not experienced that, so we need to wait and see. No,
wait and see. Thank you, Orlando. So there we have one question from Rizwan Islam on the chat box. Please feel free to use the chat box in the Q&A if you're in the audience. The next question then goes to Amy, and it was inspired by Simon Lester, who I see is in the audience. And he today tweeted that maybe if the US, the US was able to agree to USMCA dispute settlement, they should also be able to agree to the same with the WTO. So what I would like to know from Amy is, how is the USMCA dispute settlement situation being seen in the US? Is the US good? Because of course, right now, everybody's a bit concerned that if the system is too effective, the US might be raise issues. This doesn't seem to be happening, but maybe there's something going on in DC that we don't know of. Amy, you're on mute.
Okay, so the big challenge is, of course, when a government loses a dispute, and you have two disputes so far where, actually three, where a party has lost. The US seems to have complied with the solar panel dispute. That's good. I mean, they got rid of the solar panel, and I think that was also consistent with Biden policy to remove that safeguard measure. At least to remove the part of it that Mexico and Canada objected to. The second one is Canada on dairy, and there's still unhappiness. The US didn't, the thing about USMCA dispute settlement is, in theory, it should be possible. It lets an unhappy winning party, when there hasn't been compliance, they get to retaliate. And then the question is just, how much have they over-retaliated? Then could be a dispute about whether they have over-retaliated. They have a right to retaliate. So in the dairy case, the US has not retaliated, even though they're unhappy about Canadian compliance. And they have said that Canada has not complied. What has the US done? They brought a whole next dispute another round of dispute on the same dairy quotas. What's happening? Then the third case is, rules of origin, automotive rules of origin, a highly disputed economic issue. I don't know where it's going. There has been radio silence from the three governments. I see on Twitter and elsewhere that Mexican stakeholders, I think Canadian stakeholders, are not happy with, they want compliance. And they're saying, where's our compliance? We want it now. But the governments are silent. So in the end, right, what is going to happen at the end of every dispute settlement? A dispute settlement is really only an intermission. A dispute internationally is an intermission between one negotiation, the bilateral negotiation about, what about my rights, okay? And what about this commercial problem, even if I don't have rights? I want you to settle my problems. We need to have a relationship. We need to settle our problems. Then you have a dispute, and the dispute settles the rights part of it. And then after the dispute is over, you always have another negotiation about what the government is going to do to comply and how long it will take. Because in any dispute, right, even in the WTO, there are a range of ways in which a government can comply with the rules. Some of them will actually benefit the stakeholders, and a lot of them won't. So there's always a negotiation. So that's what's going on now. Is it possible, NAFTA dispute settlement kind of hit a rock? I think possibly because of problems that were built into the original dispute settlement mechanism. The negotiators this time around tried to avoid the loopholes. They tried to eliminate the loopholes in NAFTA Chapter 20, and now we have Chapter 31. We'll see how it works out. I will say one thing that's really positive about USMCA, it's fast. The panels have been really fast, and that I think is a major, major benefit. I think there's a demonstration effect that the WTO can learn from. WTO dispute settlement really is too expensive and it takes too long. It shouldn't cost $1 million a year. It shouldn't take 5 years. It would be great if it were possible to have dispute settlement in the WTO on a 90-day timetable. I know there are a lot of disputes that simply don't work, that are too complicated, but it's a great objective.
Thanks, Amy. So with that, I'm going to take the
Orlando, you raised your hand.
Yes, just a few comments. I guess that the experience, at least for the 3 years and also during the negotiation, was that the perfect was the enemy of the good, no? And obviously yes. The three parties wants to have something that it was better, and that was still in progress. But what Amy has mentioned is pretty true. Perhaps you could get the panel, you could get the panel report, and you have some guidance there. But the dispute has not end there. No, I think that the parties that was involved need to work with respect to the implementation, and the implementation could take a lot of time. No.
Yes, good point. So just to say, we have now a third question in the chat, but I'm going to leave them for after, let's say, about 6:40. But please feel free to ask your questions there. So with that, I go to Thomas Liefländer so that he can talk to us about the experience of the Commission. The Commission, of course, or the European Union has started also quite a number of disputes. We have at least 3 panel reports by now. With the Korea labor, Ukraine wood, and Saku chicken special safeguards, and has of course started a number of other discussions and political debates about enforcement, including with Mexico on the tequila case. So if you don't know this case, look it up because it's phenomenal. And Thomas, so how's the Commission thinking about this? Because of course, we all think that the Commission has a certain preference for the multilateral system, but Amy just made a very good case for bilateral trade dispute settlement being also good.
Yes, thanks. Indeed, it touches on a number of points, and I see also one of the questions in the Q&A is already going into this this matter. So I think to start with a bit of ground clearing, I think the first thing is that we don't see FTA dispute settlement mechanisms or policy as a substitute for or in competition with WTO dispute settlement. So for the EU, and this is not a secret, you all know this, restoring the WTO dispute settlement to its full functioning is an absolute top priority, and that will remain that way. Secondly, I think we have to think, and Amy touched on this already, about why do we do FTAs in the first place, which is very generically put, because we want to go beyond the concessions and the disciplines that exist in the multilateral system. So I think as a starting point, let's think about FTA dispute settlement as a complement to those additions, the WTO pluses, as we would call them. Now, of course, there are situations, and you already alluded to those, where you have the choice, where a particular measure that you are worried about is possible to address under either the WTO or the FTA. And here, in line with the general priority that we have for the multilateral, the EU has a structural preference for the multilateral dispute settlement system. Now, the reasons for that are long, and we can spend some time going into it. It's, of course, multilateral rules and multilateral forum. It's the structural support from the Secretariat, the tried and tested nature of the system, the availability of appeals, and so on and so forth. And importantly, this structural preference is not changed by the current difficulties that are existing. So that remains that way. Now, of course, we don't have a structural preference as in a straitjacket that we always have to go one way or the other. So when it comes to individual cases, you always take the totality of the circumstances into account. This can be either the particular partner, the particular issue, the particular timing. There's no limit to it, so that in individual cases, and one of the questions referred to the Ukraine Wood case, you may decide to go one way or the other. That doesn't mean that your structural preferences have changed, or that you would do the same again with a different partner or at a different time. For now, for all I know, we've had, I think, 3 disputes where there was, in principle, a choice. And in 2 of those, we opted for the WTO, and only in 1 did we go for a bilateral forum. So all of those things taken together, you basically have your preferences, but of course, in each individual case, you see what you do. And one factor that plays into this is also, how does bilateral dispute settlement actually function? I already referred to the fact that we constantly learn. We're watching very closely, of course, the very impressive speed at which the USMCA panels have been operating so far. And we're trying to learn our lessons so that when we choose bilateral dispute settlement, that of course then it works as well as it possibly can. The fact that we prefer the multilateral forum doesn't mean that we don't want the bilateral to also be fully available and operating as well as it can.
Thank you, Thomas. And just if any of you are students or young professionals and are lost amid all the talk of disputes, I have, well, first 2, let's say, small self-advertisement to make. One for Amy, who has in her Porges Law website a webpage on RTA disputes, which is very good, and which I've used as a basis also for an article that I wrote that is now in the American Journal of International Law, was published last year, so you can find almost all of the disputes we've discussed there. But Amy is the one who keeps things up to date and keeps all of us up to date on this. Amy, you wanted to make a small point as well.
So just a point, okay, about the overlap between regional trade agreements and the WTO. Look, basically every regional trade agreement requires national treatment. It has to, because if you don't have national treatment, you really have nothing. The same thing, every regional trade agreement has a ban on quantitative restrictions on trade. The other bedrock thing, if you don't ban quotas, restrictions, you have nothing. You have a completely ineffective agreement. But they go, that's true, they go beyond. So it's unusual. It was sort of very interesting that the EU decided to go after the Ukrainian quantitative restrictions on wood exports bilaterally. So, it's entirely possible. It's a political decision. It may have been, let's say, more feasible to actually address the commercial problem bilaterally than in front of a host of strangers in the WTO. I mean, what can I say? We see this also, by the way, even in this WTO dispute settlement, when a disputing government chooses between a consultation request under Article 23, and which says, I want to be alone with you and talk, and a consultation request under Article 22, which is, I want to really focus on this dispute, even if it's in a room of strangers. So back to the point. Have there been disputes about national treatment, about QRs? Absolutely. Under the Canada-US FTA, there was the lobsters case. There was a case about Canadian export ban on salmon and herring. These, interesting cases. And why did they happen bilaterally? Because at that time, the GATT dispute settlement system was a mess. There was routine blockage. There was no guarantee. There was no punishment. There was no guarantee. It was even before, I think, it was before the Uruguay round improvements that guaranteed that that dispute settlement, even in the GATT, would move forward. So that's why bilateral. And who knows? Perhaps we will see this happen again if there is appetite for rule enforcement out there among stakeholders and in governments, and if the WTO is not delivering.
Thank you, Amy. So this was very interesting, and I wonder, just to get back to my point and talk and speak to Fernando. And of course, you've been both counsel and arbitrator, and we see a disparity which may have a reason, may be accidental, let's say, between the patterns of dispute settlement right now at the WTO and in FTAs in terms of who are the complainants, right? So it turns out that almost every dispute under an FTA right now has been initiated by a developed country, and normally either by the US or the EU. And I wonder, in your experience, and of course that's also the pattern that we see in investment arbitration for different reasons, but it's not the pattern in the WTO. And in the WTO, I remember reading articles from the time when this shift happened. In the beginning was a lot of US, EU, Canada, and then now developing countries are a large part of the correspond to a large part of the dispute, including between them. You have agricultural products. You have all kinds of very interesting cases where you have developing countries using the WTO really to settle their disputes. Now, do you see this happening in FTAs? Do you see any barriers to this? Should there be an ACWL for everyone? Should ask, and I'm anticipating one of the questions Rizano Islam has asked, should the ACWL itself, of course, it would require a change in its statute, start also advising countries on how to deal with their bilateral agreements?
I think Geraldo, that's a very good question. And I think the question arises not only with respect to RTAs, but also, for example, in the framework of investor-state disputes. There have been also some attempts, to create an advisory center on investment law. And I think everyone looks at, what has happened with the ACWL, which has been, a successful, say, partnership between developed and developing countries for the assistance to developing country and LDCs. First of all, the ACWL, as you have mentioned already, doesn't have the mandate to provide assistance to developing countries with respect to a law that is not WTO law. In other words, the ACWL cannot deal with questions of RTA law, regardless of the type of RTA that is involved. And therefore, the possibility of using the ACWL as a legal platform in order to help developing countries affected by, let's say, the complications of an RTA dispute, I think is not available there. Now, the question still remains, should we think of something similar to the ACWL to deal with these disputes, perhaps at the regional level? No? I guess, if the perception of an asymmetry in terms of the defense of the interests of the responding party or the developing country that's involved in the case increases, I guess perhaps there will be room, for the consideration of establishing an organization of this sort. I believe that the question would be mostly perhaps a question of funding in that respect. I guess the ACWL benefits from the fact that it's an institution that has been created to assist developing countries and LDCs with respect to their insertion or the making effective their rights under the multilateral trading system. And therefore, it has in that respect a global scope. Now, if we're talking about regional disputes, perhaps we have to turn, to, I don't know, maybe regional financial mechanisms, perhaps development banks in certain regions may be willing to finance projects of this sort. I think we have to bear in mind the fact that the notion, the premise under which the center was, the ACWL was created, was this idea that developing countries need a legal facility to help them assert their rights under the WTO agreements. No, I think that type of, I would say, development-related model succeeded and finally led to the establishment of the ACWL. I believe that, if somebody were to pursue an initiative of this sort at the regional level, perhaps the type of premise should be considered seriously. I'm not really quite sure whether the idea of we have all these responding countries that are developing countries would be as attractive as the other one in terms of seeking funding. Because I think in that case, the funding would be basically to defend policies that might be ostensibly against trade, international trade. And to what extent that would be attractive, to financial or to donor institutions outside, I think that's an open question to resolve.
Thank you very much, Fernando. So I'm going to move to the questions from the audience, but Orlando has something to say.
Just a very short comment, and I think that goes with respect to the last intervention of Amy, of Thomas, and Fernando. And I think that we need to keep in mind that particularly many trade agreements has been incorporated any new provisions that has create perhaps some trade tensions. I fully agree that national treatment, Article 11, is the cornerstone of every FTA, and you can use both. But particularly thinking in the USMCA, I was in the intellectual property chapter negotiation. I think that 70% of the obligations are new. Other obligations, and that has created a lot of tension between Mexico, US, and Canada, are practically new, and we need to find perhaps a place to have this type of advice on how to deal with this type of disputes, particularly if these type of new provisions are more common in other FTAs. No, for example, Mexico and Europe also negotiate a free trade agreement with new provisions, and this is replicated in any other countries. And the more time that the WTO does not have these new obligations, it will be perhaps difficult to maintain the regular use of the WTO system, besides the fact of the crisis of the appellate body or wherever. But I think that we need to keep an eye of this new type of provision and capacity to solve those disputes, and groups like ACWL to deal perhaps with the regional component of this free trade agreement obligations. No.
Yes, a very good point. And but let me then I think in a related fashion, and maybe I'll press Thomas on this on behalf of Pinar Artiran, who asked this question. When you have the option, right? Sometimes, often you don't have the choice, and that's of course then there's no question. But could you enlighten us on a bit on what the criteria that the Commission is considering, maybe in very Commission fashion? It's already coming up with guidelines for this to decide where to start the dispute.
Yes, thanks for the question. So, as I said previously, it's really a totality of the circumstances, and I feel that this is not going to have become a lot more granular now, because I couldn't, even if I wanted to, give you all the factors that play into each decision in every case, because they are by definition different in every case. So in some cases you look really at what is the nature of the measure, what is the particular bilateral dispute settlement mechanism you have at your disposal. Is it one that is a bit old and outdated, and you don't have that confidence that it's actually going to work. In other cases, you might have a shiny new one that you're eager to try out. You have obviously general political considerations about the bilateral relationship, where the multilateral situation stands, what you want to signal also there. So there's a whole host of considerations that go beyond the simple question of where can I legally address this, this dispute. As I said, I think our default mode is that we look for those disputes to the multilateral stage. But again, what in a particular moment in time with a particular partner and a particular measure might ultimately sway the Commission to decide one way or the other, that really is very much case by case, and not only driven by pure dispute settlement policy, but also the overall political picture.
Thanks so much, Thomas. And I have Amy and then Fernando.
Well, I have actually a question for Fernando. So, which is, so Fernando, okay, you have been a panel chairman in a CAFTA dispute, I think, and between two developing countries, in fact. And I think you also really closely familiar, I think, with dispute settlement under the Central American Common Market, operated by SIEL, which is extremely, actually have been very active. 34 disputes between developing countries. And so my question is, how does a Central American country decide? And by the way, SIEL has produced 4 panel reports. Okay, so it's not just consultations. So how does a Central American country decide between the two forums, the 3 forums, WTO versus CAFTA versus the SIEL? And also another question, which is, who's bringing these disputes? Is it the relatively larger partner or the relatively smaller partner? Because I also don't think that free trade agreement dispute settlement is just something that's brought by big countries against small countries. But that Fernando knows for sure.
Thank you very much for the question, Amy. I wanted to make a comment on the basis of what Thomas was saying, responding to the question from Pinar, but I will also take advantage of this opportunity to address Amy's question as well. And of course, I don't really know what is happening, in the internal decision-making process of the Commission in terms of choosing between one forum or another. But I think in general terms, and I think this is like one word to draw, big lines about the different considerations of countries in order to bring a dispute between one or another forum. I think at the very least, I guess one can look at 4 different dimensions. I think there is one which relates to the nature of the measure. Of course, it makes a difference whether you want to challenge a subsidy, which is a production subsidy that would have effect, on exports, towards the whole world, as compared to a country-specific measure that would only affect imports or trade with a particular trading partner. So that's one dimension of this complex decision-making process. I would say a rather complicated matrix. I think the other one is the question of the law as well. Even though you may have overlapping provisions, overlapping obligations at the multilateral level, at the regional level, we have the benefit in the WTO of extensive jurisprudence, of extensive case law, and well-developed legal standards with respect to certain obligations. And we have a secretariat that is familiar with that. As a matter of fact, we have all other WTO members that also know the case law, and they can contribute in the context, in the course of the process, where there's admission of third parties. So the second dimension is the question of the law and the previous practice or the previous precedent that you may have under the relevant jurisdiction. I think there is a third one, which goes to the question of the management of the process. And I think that might relate in a way to the point that, I'll go back to Amy's question a little bit later. But I think in the WTO forum, you can benefit from something which is called economies of experience, in the sense that you have a very well-established institution, you have a very well-established legal affairs division, which is quite familiar with the handling of these disputes. Whereas if you decide to start a dispute, to launch a dispute in a regional forum for which there is no previous practice, you have to be very careful about the choosing of the adjudicators, the arbitrators. You have to choose people with extensive procedural experience so that they can handle very efficiently not only the merits of the case, but also the logistics and the organizational aspects of a dispute. And that might be a very significant burden, okay? You have to deal with the correspondence between the parties, which might be very burdensome depending on the frequency of the changes. You have to deal with the issues of procedural orders. You have to deal with the organization of the proceedings as such, particularly the hearing. There are some FTAs that have provision according to which the responding state becomes the state hosting the hearing, and then you have to incur in some sort of like implied ex parte communication for logistical reasons with that party in order to arrange the hearing. So things might become from a logistic angle a little bit more complicated if you were to go regional as compared to WTO. And there is a question, the fourth dimension is the question of the length of the process. I believe, I guess in that respect, perhaps some regional mechanisms might have an advantage. We have heard the experience of what is happening in North America, which apparently, you know, have led to very expeditious decisions. WTO is going through a difficult time nowadays. We all know very well what is happening there. But I just wanted to raise, you know, these different considerations that may be in the mind of some government officials in deciding whether to go regional or go multilateral. Now, in terms of Amy's questions regarding dispute resolution in the Central American context, yeah, the CAFTA experience was a very interesting one. I think it fell under that box of a dispute for which there was no previous practice. I think there was the first state-to-state dispute, and therefore those who were serving on the tribunal have to deal not only with the merits of the case, but also, you know, with setting up the relevant procedural rules, despite the fact that there was already, you know, a code of rules of procedures. But nonetheless, there are always, you know, unexpected situations that may arise, and there you have to deal with them on the spot. So it really requires, I think, dedication, an extra dedication, I would say additional dedication to what you could see in a WTO panel proceeding. We did our best to, you know, meet all the relevant deadlines. In fact, we rendered a report within 6 months, which is what was provided for in the CAFTA. But certainly, I mean, we didn't have the assistance of a secretariat like the WTO secretariat. Now, in terms of the functioning of the SIECA mechanism, I'm very glad that you're referring to SIECA. It is not really that well known what is going on in this part of the world, but in fact, it's a very active mechanism. As you mentioned, there are more than 30 disputes. Countries resort to this mechanism on a regular basis. And the type of countries that are involved are countries which are not, let's say, in an asymmetrical position. We're not talking you know, about large developed countries against small developing countries. There are more or less, you know, in relative trading terms at a certain similar level of trade, and the mechanism is functioning well. I think there is confidence in the system. Countries are coming very regularly. What is the reason why they may want to go to SIEC as compared to WTO CAFTA? I guess it is a question of the law, maybe. I guess if you look at those disputes that have been brought by SIEC under SIECA, those disputes relate to obligations that arise under SIECA or under Central American law. In the case of the CAFTA dispute in which I was involved, there was a question, a big picture question as to whether the obligations contained in CAFTA were of a sort of like plurilateral nature in the sense of, you know, obligation linking the 5 or the 6 different parties to the CAFTA, or they were obligations of a bilateral nature towards the United States that were put together in a single instrument. And if you look at the award of the tribunal in that case, I'm not saying anything that is not public. The award makes it very clear that you have to make an assessment, provision by provision, and there may be some obligations which may have this plurilateral character, while there may be some others that were conceived as obligations of a bilateral nature towards the United States and not binding the other respective co-parties of CAFTA. And I think that may have been the main reason why in that specific factual situation, the parties decided to resort to the CAFTA tribunal instead of going to SIECA. But I have the general impression that is basically based on the applicable law and the question of to what extent there are specific obligations that arise under SIECA, then the Central American countries will go to SIECA. If not, they will have to look at the other forums that are available.
It was super informative. Thank you so much, Fernando. And I think I'll pose two more questions, and then we go a bit over time, but then that's because we also started at 05. So the first is to Orlando. So it comes from Desiree Leclerc, and I'm going to rephrase her question a lot, or a bit, I guess, as my Freudian slip there. So we're discussing about the possibility of under enforcement and what are obstacles to enforcement. So she asked if specifically regarding to the rapid response mechanism in for the labor enforcement, if there isn't over enforcement in the sense that the U.S. decides unilaterally what it wants to enforce, and then this is done directly towards the company rather than going to the government. Is there any discussion in Mexico about this being a problem?
No, I guess that with respect to enforcement, at least in reviewing the text, it's quite clear that the state-to-state dispute has the same elements of enforcement that we have in the WTO. So when the parties receive a panel report, and the panel report is basically circulated, adopted by the parties or published in their websites, there is a timetable to negotiate a plan to implement the obligations, and if not, the other party can retaliate. Or they can have a specific dispute with respect to the measure taken to put the measure in conformity with the decision, no? Or an equivalent of the 21.5 of the WTO is also there. Or they could have a dispute with respect to the level of the retaliation measures. But when you make the analysis based on the rapid response mechanism, we need to take into consideration that this mechanism is, I will say, a sui generis mechanism, because it's not necessarily a state-to-state dispute. They have some elements there because it's triggered by a state against another state that is requesting an investigation of what is happening in a particular facility. In Mexico, it's basically a bilateral mechanism. We have Annex 31, I would say, A and 31B, so one for Canada, one for the US, but it's basically against what is happening in Mexico's own facilities. And if this issue moves to a panel stage, obviously there will have a more sustained proceeding, and the sustained proceeding is only dealing to have a determination of what happened in that facility and suspend the benefits to that facility, and not necessarily a suspension of trade benefits against Mexico as a state. So there are some relevant differences. That's why perhaps that the facility that is basically the company that has receiving the claim or the case has some incentives to cooperate and to try to solve the problems.
Thank you. Amy has two fingers.
I think what am I okay? I'm not muted. I think what Desiree Leclerc's question was about was a suspension of liquidation. That is, that the agreement provides that if the USTR requests the Mexican government to investigate conditions in a particular, let's say, a particular factory, about a labor dispute, whether there's a denial of labor rights. At that point, USTR gets to request the customs authorities in the US to suspend liquidation. That is to basically hold in suspense the settlement of customs accounts on imports from that factory. Okay, and as Orlando said, this is a powerful motivator for the factory owner to come to the table and figure out a solution, and it facilitates the government's efforts in also settling the situation, and it does take place against the background of the new labor law that was enacted by the Mexican government. And the suspension of liquidation provision was something that is in the agreement and was agreed by all three parties. So is this a denial of due process? Well, it's an agreed process. It's in there, it's in the agreement.
I agree.
And in a sense, and I think, again, I'm not a Supreme Court lawyer, but I think due process rights with respect to imports are somewhat more limited, let's say, for the exporter. I'm going to stop saying anything about that. But okay, just that's all I have to say.
Thank you so much, Amy. So I'll have a last question, and to Thomas, actually, because there have been quite a few questions on the interaction between these new provisions and agreements and WTO law by Surinder Singh, Julian Mirao, now Gabriel Marceau, Edna Ramirez as well. So what is the thinking? Because let's say we got used to the idea that these are just self-contained regimes, right? So these are just not, they don't really interact. But of course, there is, of course, every once in a while someone talks about the bringing these issues to the WTO, at least substantively the same obligations. Now we have the fishery services agreement, so it's not inconceivable that the WTO will have some sustainable development obligations as well. So is there any discussion on a sort of integration here? And Gabriel Marceau asks about also what happens if there is a violation of WTO law arising out of retaliation in that commitment. I don't think we have time for the long legal analysis, but maybe there is some discussion going on.
Yes, thank you. I'll try to be brief. I think indeed the question of how do the rights that you might obtain under RTA dispute settlement and the WTO obligations interact is an interesting one, and one that probably deserves a bit more attention going forward. In our recent practice, at least, we've started addressing this more head-on in two ways. Of course, we have on the one hand a choice of forum provision. So you have to make your choice when you have the choice, and then you're stuck with it. But secondly, also, if you prevail and obtain then retaliation rights, those should not be constrained to what you have gotten, let's say, on top of the WTO. So you would be able to retaliate also beyond your WTO commitments. And in that case, the losing party is not permitted to invoke its WTO rights against your retaliation rights. So that's something that we address now in the FTAs. Of course, if this is brought to the WTO, let's see.
So I think with that, we have, unless Amy had two fingers to discuss this or not?
I think that's enough.
Okay, fantastic. With that, we bring this conversation to a close. It has been fantastic. Thank you so much to the audience for staying with us and for asking all these interesting questions and allowing us to debate these issues. Thank you to all the participants. Thank you to the Executive Council of the SIEL for trusting me with organizing these, and to please follow us on Twitter again at SIELnet. And follow all the people here who are on Twitter, who are myself, Amy, and Thomas. Thomas, sorry, I may increase your follower account. I know you have more of a reading Twitter, but there you go. So, oh no, Orlando as well, right? So I saw the TME Abogados at least is there. I don't know if who's managing this, but still them as well. And thank you so much to everyone for staying with us. And I look forward to seeing you in Bogota if you're going to Bogota. Otherwise, online in one of these events further. Bye-bye.
Thank you. Bye-bye.